Well, welcome to the third in our trilogy of sessions about legal research. My name is Michael Green, and I acknowledge the Gadigal people of the Eora Nation, the traditional custodians of the land on which Chambers is located and from which we are broadcasting to you today, and I pay my respects to their elders past, present and emerging, and I extend that respect to Aboriginal and Torres Strait Islander peoples joining us today wherever they're located. We have a large number of attendees today from all around Australia and some from New Zealand I think as well, so welcome. This is the third in our series trying to look at ways in which we can become better at performing legal research, and today's session is about statutes and how we work with statutes, but you'll see that we will recap and look a little bit about what we've learned so far in our session. The webinar is available on YouTube. It's being streamed directly to YouTube, and it's also available for those that wish to watch it on Zoom. The YouTube code I think is available in the Zoom window, so you simply need to look at the Zoom window to find the YouTube video. And I'm hoping that partway through our session today we're going to have a live cross to Patricia Lane, a member of Chambers here, well, one of the members of Chambers here, Level 22, who will talk to us a little bit about statutory interpretation and how that, and her experience with statutory interpretation. She teaches a course at Sydney University on it. All right, let's go to the overview and I'll talk about what's happening today. So today's session, recap, just a reminder, it's available on YouTube, in the YouTube channel, both for Level 22 Chambers and also for Barnett's, for the Jade YouTube channel. We have three parts today. We're going to talk about statutory materials, how to work with them, what they are. The second part will be statutory research tips and examples, and the third will be using the results of a research. And we'll have some practical examples for you, and we'll have a live demonstration of some aspects of research. But you're welcome as ever. This is our second deep dive, and while I use Jade to describe and illustrate the legal research process, we'll also look at the authorised sites for statutes that you might look at around Australia, which are very useful forms to get authorised versions of statutes, and we'll also look at doing the same things in AustLII if you wish to know how to do that. You're going to have research questions. We're here to answer them and we're here to look at them, and really the way that we've made Jade better in the past is through participation, through questions that you ask about how do I do such and such a thing within Jade, and then we often endeavour to change Jade to make it easier to achieve that purpose. And so many of the suggestions we've had from previous sessions in this trilogy have made Jade already better. We've made some changes to improve things. All right. Well, and the other reminder is there's no one right way to undertake legal research. There are plenty of wrong ways. There's no one right way. The only way you become familiar with legal research is by practicing it, by doing it, by attempting to do research and then seeing what works and what doesn't. And the best time to practice is when you have a bit of spare time rather than when you're in a desperate hurry to try to find absolutely the right answer to a particular problem, because we get a better feel for it. All right, so what is statutory material, what is not? If we can go to the next slide. After the questions. Sorry, on a recap, let's do a recap first. You'll remember on a recap on page 4, if we could, you'll remember this slide that we had from the first time. I looked a little bit different because I was quite jerky and I moved a lot. We've improved the quality both of the video and the sound now, and my mouth and the words coming out of it should be matched. You remember our 10 points, and moving from the 10 points, I want to now look at the detail of statutory research. And so we'll go to the next slide, please. So there are many reasons to undertake statutory research. We can do it for current awareness. We can keep up to date through setting alerts, doing some comparative statutory work to see what's happening here in other jurisdictions, and also we might want to have a look at the bills sites within parliaments around the place so that we can work out pending legislation. Now, there are some commercial services available that provide you with updates about pending legislation, things called bills, and also pending statutory instruments. And the JADE system will shortly add that material in as well. So we're in the process of enhancing what you see today in legislation to include that kind of current awareness. But at the moment, the current awareness is confined to statutory material and to statutory instruments and regulations. So that is material that has passed into law or material which has been repealed. The things which are pending or things which haven't yet come into law, that is bills or enactments that haven't yet passed and that haven't yet been documented as pending within a particular legislative instrument, that material is not available yet on JADE, to keep things simple. The understanding pending legislation, of course, is a challenge, and that can often require you to have a look at the bills and to work out something about the stage at which a bill is at in terms of its consideration, whether the bill has passed to a committee for consideration, and whether that consideration has led to any kind of report, and whether that report is with the government to determine. So they're quite complex areas, and we don't have time today to go into the detailed historical work about what turns into an enactment, but we will have more detailed deep dive sessions later about how to do that kind of research once it's available properly on JADE. An important part of our research activity is, of course, to find, just as it is for finding authorised reports, it's important to find the best reprint or the best version of a statute or statutory instrument. And the best version of a statute or statutory instrument is the authorised version. And it's very important that if you're working with courts, you need to make sure that you use the authorised version. That's not the printout for AustLII, but that's the version that's available on the authorised sites for legislation. So in New South Wales, that's legislation.newsouthwales.gov.au. We'll provide those links in the materials we provide to you. In the case of the Commonwealth, it's legislation.gov.au. In the case of Victoria, it's legislation.vic.gov.au. And there are various other sites. Each state and territory has an authorised legislation site. Those sites are maintained by the Office of Parliamentary Counsel, or the equivalent body, parliamentary drafts people in various locations, and that site will tell you whether something's been repealed or not, and often will contain links to bills material as well, so you'll be able to link back into the relevant parliament to see what's happening. The other aspect of finding the best reprint is often finding the best point in time, the relevant point in time. So often courts will want you to provide either all or some of a legislative enactment as at a particular point in time, and part of the challenge is to work out which bits you need to provide and then how to provide it in the version. Now, it's very easy in the Commonwealth site because there are consolidations at various points in time and you can track through it. It's very easy in New South Wales because there's a historical version in New South Wales, and it's now easier in all sorts of other states and territories, but you need to work out what point in time are you dealing with. The other aspect of that is how to find a statute that relates to my problem. Now, just as we had a problem in searching for case law material just by using full text, it's quite hard to search in statutes for using full text to find a term that covers a particular area. And we're going to use the idea of the searching about goats today. I have a little goat here, but thankfully Jackie Charles, our clerk, has indicated the interesting area of research where a goat appears in legislation, how a goat is managed through legislation, particularly in New South Wales, is quite an interesting story. And you'll find that if you're trying to work out what your rights are relative to a goat, or what your obligations are towards a goat, that can be quite a tricky topic. And amazingly, well, probably not amazingly, you can't just type goat in to a search engine and get a result that helps you immediately. You'll find that the legislation has changed, and we'll do that in a moment. Understanding changes to statutes are particularly important. There are two dimensions to that. One is understanding that a change has been made, and the other aspect is understanding how that change affects accrued rights or prospective rights and entitlements. So does the change have a transition? Does the enactment have a retrospective effect, or do accrued rights at a particular point in time, do those rights continue under the old legislation? And that can become very difficult in terms of thinking about statutes and how statutes operate and how they're deemed to operate. And sometimes you'll find deeming clauses and the like. That's part of the process of statutory interpretation, but it's important to, through the process of legal research, to assemble the right statutory material so you can undertake the process of statutory interpretation. Changes to statutes are an interesting area and often quite complex for two reasons. Firstly, the change to a statute, a section might be amended directly, and that may give rise to a change. But alternatively, a definition in a statute or a definition in another statute might have an effect of incidentally amending the meaning of the statute you're considering. So it can be quite complex to work out the interplay between different legislative regimes, and you need to be careful to understand how the various parts of a statute might have been amended and what that means for your particular problem. So don't assume that simply because the section you're looking at hasn't been amended that means the Act is exactly the same and has the same effect to a case that you might have found considering that section from an earlier period. Because what might have happened is the definition might have been expanded to include other things, or there may have been other incidental amendments that may have an effect, or there may be pending amendments that haven't yet come in, and so if you're giving advice prospectively about the right to do something, the likely right to do something, you'll find a difficulty. The full text format that's best for court is invariably the material available from the authorised sites, and what we've done in Jade is we've made it so that any time you look at a statute in Jade, just as you can with case law, with legislation, you can click through and get the authorised version, in this case either a PDF or a Word document, or a link to where you can download it from that exact version you can download from the authorised site. So we always give a link back to the authoritative version. Now, just to remind you about what we talked about in our first session, and this is being our last session that's important. I talked in the first session about the 4 C's. That's coverage, currency, connectedness and content. And coverage is really important when it comes to legislative material. So you want to know that the legislative material you're looking at is up to date, and we spend a lot of time, the currency, we spend a lot of time looking at it. And we want to make sure that there's coverage. That is that states and territories are all linked. And if you want to search particular legislative enactments in different states and territories, you want to know that the material is available so you can search through it. Connectedness is important because we link both in Jade, we use the same parsers, and we link to other statutes that might reference that statute or regulatory instruments. We also link to case law that considers the particular statute, and that can be quite handy. And the last point about it is content. The important part about content is that you want to make sure that the content is correctly rendered, that it looks like a statute, it looks in the correct form. Now, a lot of the statutory material that's available online from the various sites, for example, the very early materials available from the legislation site in New South Wales and other sites, is available in PDF form as an original scan from the statute books. So it won't be coded in like you'd expect it as text. You'll see it as a PDF. And what we've done in Jade is we've scanned that using special OCR tools so you can basically search that. It's not perfect, but it's a start, and we're basically improving the text as we go. So let's go to the next slide if we could. What is statutory material? Well, we need to know what it is and what it's not. Well, it's fairly easy. That's a fairly easy question. you'll remember our definition of primary law. Statutory, when I talk about statutory material, I'm talking about that species of material that's everything but case law. So statutory instruments, enactments and various other regulations and rules and everything that goes with that. In the common law tradition, the contested meaning of statutory instruments is settled by courts as a process of statutory interpretation. We know that, and we know that text, context and purpose and the canons of construction operate upon that. So when we talk about statutes, we're talking about statutes and statutory material, we're talking about statutes and statutory rules. And statutory rules can be referred to as a regulation, a bylaw, or a rule, or an ordinance. So the rules of court are a statutory rule, in effect, they are statutory rules. They're made under a rule-making power. They're often made in a different way to some other statutory rules, but they have the same force, and they're stored in the same way in the various official sites. And we index those, especially within JADE. So the UCPR, you can search in JADE for particular rules within the UCPR, and you can do the same thing for the particular parts of the Federal Court rules. And also, in the case of Federal Court rules, you can search for the earlier Federal Court rules before they were amended in 2011. So you can get cognate references. So that even if the provision of course has changed in many cases in the current Federal Court rules, but you'll be able to find some earlier case law in a similar area or using similar forms of expression, and you can make a evaluative judgment about whether or not that material can help you in your search for legal principle. So then, some statutes have definitions, and the definitions are sometimes the front or the back, and they're sometimes by reference to other statutes or other materials, and so you need to know roughly how to find those definitions or how to incorporate that. You need to know about how to cite a statute or how to cite the version and how to go on the documentary trail. And again, that's something that requires practice, and there's material that we've got, instructional material we've got in JADE that will provide you to do that. I won't talk much about it today because it's better through a process of practicing. There are better options to undertake than full text searching, and we'll talk about when to use that. And once you know your research reason, as with case law, with statutes as well, once you know your research reason, then that really helps you to understand the best place to start. So for example, if you know that you just simply want to find the text of a known section of an Act, you're not interested in the history of the provision or the history of the Act, you just want to know what, for example, section 136 of the Evidence Act says, in, say, the Commonwealth Evidence Act, New South Wales Evidence Act, or some other Evidence Act that happens to be the Uniform Evidence Act. You want to know what that says, you simply can type in section 136 of the Evidence Act 1995 CTH in JADE, and that section will pop up. So you can quickly get to the particular provision if you need to see it. And as with case law, you can look at the whole Act, and we're working on ways in which there'll be section viewers. So it's similarly to AustLII, where AustLII by default pops up a single page for a particular section of an Act. If you click through from the index of an Act in AustLII, we're doing the same thing to make it easier to work with statutes within JADE, and that gives us some other features we'll make available in that way. I've already mentioned authorised and unauthorised versions and annotations. When you're working with things like annotations to, say, the Australian Consumer Law or the Competition Consumer Act, which has the Australian Consumer Law as a schedule to it, say Miller or other services that are publications, just be careful that you're checking against the authorised version to make sure that the version that you're looking at is the current version. So while those services are quite handy to compile cases that might be of interest to you, just be careful that when you shouldn't cite those annotation services as an example of the Act to courts. You should go and find the authorised version in its pure form. And so too of, say, Odgers on the Evidence Act or the Uniform Evidence Law or other compilations. It's dangerous to do that. You'll need to check things. All right. Well, if we go to the next section. We've already covered this, but we want to make sure that we understand that there are a wide range of material. It comes in a wide range of forms, comes in a wide range of typesetting, and it has quite a different layout, you'll find, to the layout of a case, of course. There's of course the introductory section to an act, which gives you something clue about the history of an act and how it came to be made. And the most important part of an act is in fact at the end, where there are notes that give you quite detailed information about the history of the amendments to sections and parts and divisions, and we replicate that in Jake graphically, but it's always important, you should always look at the end of an act to see the history, and you should always, if you're looking at a section of the act, to check how it's been amended or what its history is, if you're particularly interested in it, and of course if it's for the purpose of getting a better understanding of historical versions. And the reason for that is if you get the most recent version of the act, often when you're advising about something, you are really looking back in time. You're doing time travel. You're not talking about the present, you might be talking about a period in the past, and it's Murphy's law of statutory interpretation that frequently acts will change at exactly the moment that matter to you, and you'll find that if you simply give advice based upon the first bit of legislation that you turn up, you may find yourself in a world of danger. Now, if we can go to the next page, please. So there are some acts that you really should keep in mind at all times. There are the interpretation acts. They're like the super acts that supply meaning and definitions to other acts without the need for those acts to have that material in them. Now this, you might be able to see it on the screen, but it's quite fine. But this is a good example where full text retrieval won't always get you if you searched on interpretation, you would get everything but the ACT, because that's called the Legislation Act. But the other acts, all of the other acts, are all various versions. They all have a similar heritage, but they're all various versions. And depending upon the moment in history that the particular act was made, they either are called the Acts Interpretation Act in the case of the Commonwealth, and of course that's been amended very many times since to add additional bits in and to make important legislative changes. In South Australia it's called the Acts Interpretation Act 1915. In Tasmania it's the Acts Interpretation Act 1931. Queensland it's the Acts Interpretation Act 1954. In the Northern Territory it's the Interpretation Act 1978. In Victoria, it's the Interpretation Legislation Act 1984. In Western Australia, it's the Interpretation Act 1984. In New South Wales, the Interpretation Act 1987. And in the ACT, it's the Legislation Act 2001. Now, they all have slightly different formats, but they all are cognate in the sense they all do the same sort of thing, which is to give various bits of meaning to an act. Now, one of the curious facts in New South Wales and in the Legal Practitioner Uniform Law is the Legal Practitioner Uniform Law is in fact an act of the Parliament of Victoria, so that when you come to interpret that act, the Uniform Law, you need to use the Interpretation Legislation Act 1984 to interpret it. When you come to interpret the Uniform Law Application Act for the Legal Profession Uniform Law Application Act, you'll need to use the Interpretation Act 1987 New South Wales, and so it shows you the level of detail. Now that may not have any practical difference, but if you're a purist and you want to show that to a court that you understand what's going on, it's important that you know the difference, and it's important that you use the right act for the right interpretive task. The second thing you should always know, have in the back of your mind, is constitutions. Now I've been cheeky by saying statutory bodies, but certainly you shouldn't have the constitutions of the Commonwealth. Commonwealth Constitution, of course, is a critical constitutive document. You should know something about the constitution of each of the states and the various foundational documents of the territories as they achieve self-governance, which are offered in Commonwealth Acts, of course. And you should, if you're dealing with statutory bodies, you should know something about the constitutive documents that led to the founding of those bodies. And they are, if they're statutory bodies, you'll find them in an act. But you might also find them frequently in subordinate legislation of various kinds. So you need to know something about that. You also need to perhaps spend a little bit of time knowing something about the Judiciary Act as a pleasant reading exercise, because it helps you understand something about federation, also something in parts of it about how laws are to be applied, federal laws to be applied in the context of a federation. And you should spend time with the rules of court, because the rules of court around Australia and rules of court in different courts are quite different. There are similar themes, but they use quite different language. So until you have a feel for what the legislation, what the rules of court are, you can often, using full text, you may miss a particular part of the rule that you wish to find. And that's really why one of the easiest ways, one of the best ways of looking through legislation is to start with the table of contents, or start with the index at the front of contents at the front of the Act. You'll get a feel for the organisation of the Act, how it's organised, which bits might be relevant. The other thing about a statute is always make sure that you look at the miscellaneous provisions. The bits at the end are often quite important and can quite modify what you think of the ordinary operation of the rest of the Act. So a pro tip, do that. Another pro tip is don't expect that every statutory instrument, that is every statute or regulation, will ever be considered by a court. The vast amount of statutory material means that won't happen. And one of the challenges of the researcher, when you're dealing with researching statutory material and also trying to do legal research in relation to statutory material, is to find cognate legislation that may have been considered. That's similar words and phrases that may be relevant to the question you're being asked about the meaning of a word. Of course, text, context and purpose means you need to look at the instrument itself, but you can often find some useful ideas in case law that might help you in how you go about reasoning about what the meaning of a particular term is. So, of course, don't assume that a word X, say dog, means dog in every statute and therefore it's universal. Of course, if the word dog appears in the Acts Interpretation Act, then you would be able to say that meaning will apply unless a contrary intention appears. But otherwise, you are limited to thinking about the meaning of words in their context in an act, and that can lead to quite different counterintuitive results. I mean, common sense always applies. Statutes are written in English. Common sense approaches apply to that, but at the same time, there's always the creativity of a lawyer in how one comes across in relation to that. All right, so then the next slide, if we could, please. One feature of modern statutory material is that statutes cover multiple, that's omnibus issues, and they consider them in different parts. So that's the first point you need to know about. The other thing you need to know about is is that often you'll find, if, for example, if the name of an organisation changes, and that organisation appears in multiple statutes, there'll be an amending act that simply changes the meaning of, redefines that entity across a whole number of different statutes. Now, those acts, those amending acts, can be very useful to see if you didn't have full text search, or if you didn't have the ability to search using electronic means. Those acts can be very useful ways of finding where a particular body is referred to in different legislation and getting an idea of for example, the regulatory extent of particular operations of particular organisations. So you can use those amending acts to get a feel for legislation that might be of relevance to you that you didn't know anything about. But the other way it's important is that in omnibus legislation, say the Broadcasting Services Act, there's a whole lot of sections to that act that aren't really, they are related to broadcast in the broader sense, but you'll find that certain practitioners will need to look at certain parts of it, not others. And it's true of a whole lot of other legislation. The Telecommunications Act is now a sprawling mass that includes all sorts of matters relating to telephonic services because of constitutional power, but it also, of course, has a much wider remit to a whole lot of areas, data retention and the like. The other thing you need to know is drafting practices are vertical and they're not horizontal. That means that you'll find there's an attempt by Parliamentary Council in each state and territory to maintain a consistency in language over the generations if they can. There'll be changes made to improve the clarity and of language used in statutes, but you'll find that there's a reluctance to make too much change because phrases are used consistently, and if the same concept is used in a different act, then the idea is that there'll be a consistency of language, and that's a great discipline that Parliamentary Council use. You also find that there are quite different writing or drafting styles in different parts of Australia. That's no criticism, it just means that you'll find that there are different terms of phrase, different expressions. Some of that comes from the fact that the Interpretation Acts have pick up different phrases, and so therefore different words are used for that reason. But there is a consistency, but it is a it's a vertical consistency, not a horizontal one, which means that if you're searching, you should look in the legislation in particular jurisdictions to start with, get a feel for it, and then branch out. If you're trying to do a research to see what are the legislative provisions in relation to something across Australia, as with case law, often the fastest or the best way is to look at some secondary legal materials to get your bearings, particularly in complex regulatory areas such as, for example, energy law, or in, for example, the regulation of pharmacies or the like. You can find that secondary material can help you get your bearings. But again, you need to always ground truth that, and you always need to come back to checking that material in the primary materials if it's critical and it's important. Don't assume that between the time that the secondary material is produced and the time which you need to use it, there hasn't been a change, because there is a large amount of change all the time. The last point is about the drafting practices. Is it can be hard to find definitions, because even in say the Commonwealth, there was a period of time where the Commonwealth, the Evidence Act is an example of this. In 1995, the practice was to put definitions at the end of an act. At all other times, before and after, it's been to put it at the front of an act, but you'll find that in 1995, for some reason, the Evidence Act proposed using a dictionary. So what you find is a dictionary is basically a schedule to the Evidence Act, which is referenced by a section of the Act, says the definitions are in the dictionary. It's the same in other acts around that time, and it leads you to having to pass forward and backwards. The other issue, which is not really a definition issue, but there's a drafting practice rather quirky, in the Competition and Consumer Act, what actually happened with the Competition and Consumer Act is it is actually a renamed Trade Practices Act. So the Trade Practices Act 1974 became the Competition and Consumer Act 2010, and what then happened is, in a schedule to that act, the provisions that used to relate to Part 5, the consumer protection provisions, were reenacted obviously with sectional changes as a schedule to the Competition and Consumer Act, and that schedule is called the Australian Consumer Law. Now that's incredibly hard for people within J to model, but it's also very hard for courts when initially the Australian Consumer Law came out to work out how to refer to it. Does one refer to it as Schedule 2 to the Competition and Consumer Act, or does one say the Australian Consumer Law? So in that transitional period, when courts were becoming familiar with how to refer to it, we're now well past that point, people had trouble about working out how to cite it. And you'll find that it's quite hard. If you're looking for references to, say, Section 18 of the Australian Consumer Law, it's quite hard to find that in the early stages after the Schedule 2 came into being. And of course, if you're looking for a heritage of an act, and you're looking, for example, for cases on Section 52, you'll need to know how those things map. And so there are systems available, and of course Jade provides some of that, and other systems provide that, where there's a mapping. So you can find if you're an older practitioner, what's the new reference to Section 52? But if you want to know what was the earlier case law that developed from 1975 or thereabouts through to the change of the regime with the renaming of the Act, that's important. The other fun fact is in New South Wales, the Gas Act became the Electricity Act, and the Electricity Act became the Gas Act, or vice versa. I can't quite remember how. And one of the interesting points about that is that if you're searching through acts can change names. So if you're looking for an act, it's within the power of Parliament to change the name of an act, to give it a different date and the like, and it can be quite tricky to work out how that fits together. And it can be devilishly complex if you're trying to find references. So if you're trying to find a reference to, say, the Gas Act, because the section, you want to find a history of the use of the section, and you're looking before it changed its name to the Electricity Act, you need to search for Gas Act and vice versa. So there are those challenges. Now, they're not everyday challenges, but they're the edge cases that make it important to know something about how to do statutory research and to understand that acts can change their name, they can be repealed, the other acts can be lobbed into their place, it can be very hard to find things. The last point about it is the Henry VIII clause, which is a provision that allows for delegated legislation to override primary legislation. So it's a rulemaking power that basically allows the rulemaker, the delegate to change the primary legislation, or to not change the primary legislation, but to enact something that goes beyond or is inconsistent with the primary legislation, which of course you can understand has issues for the limits of executive power, or removing limits of executive power or parliamentary oversight. They're regarded as troublesome provisions, but you find them in different locations, and that can be why it can be quite difficult to find what rules that are made. You may need to look only in the regulations to find changes in rulemaking powers where the Act itself gives rise to a Henry VIII clause. That's a research challenge. You'll find, if you look for Henry VIII clauses, you'll find recent discussion in the High Court about them, and you also find, of course, discussion in a lot of literature and parliamentary reports about the danger of them and the undesirability and why they're a bad thing for a democracy. We go to the next page. So, what are the features of statutory instruments? Now, this is where we're going to jump off shortly into a demonstration to show you something about the features of statutory instruments. But you need to know something about the anatomy of a statute when you're getting started. So you need to know that there are, obviously we know about sections, but you need to know there are divisions, there are parts, there are divisions, and there are sections, and that can be relevant to understanding and navigating your way through an act, particularly complex piece of legislation. You need to understand something about whether there are schedules in the act, how they might work. So it's always very helpful when you first read through an act, if it's an act that's important to you and you think it might be relevant, is to just look at the table of contents, work out what's in the act. Are there a lot of schedules? Why are there schedules there? What do they do? Are they there to hold provisions that are transitional provisions for previous revisions to the Act, or do they do something else you need to know about? So find your way around the Act. Work out, when you first do your first read through, work out whether there are regulations that are made under the statute. So work out what is the position of the statute, what are the position of regulations, because it can help you understand the interplay between the two. Often people start with the statute and then go to the regulations, but it's a good idea to see what are the likely regulations made under the statute. And there may be more than one, and often there is more than one set of regulations made under a statute. There may be one set of regulations made under a statute on a complex series of topics, but that's again a question of practices. Practices change. So, for example, under the Copyright Act, there used to be separate regulations made for different topics, different subject matter, international protection regulations, copyright tribunal, and the like, and then that was rolled in more recently into one omnibus regulation to cover those various parts. The previous regulations were separate into one holistic regulation, which means that rather than being able to carry around those bits of regulation, you then need to find the part of the regulation that relates to it. So there is obviously a need to just get a feel for the statute, the regulations, the regulation power. That's the first read through. The second read through, when the second time you come to read through a statute, spend a little bit more time looking at where the definitions are. So then leave it for a bit, look at the definitions, see how the definitions operate. Definitions may appear as general definitions, or they may appear as definitions within the section or the provisions that you need to look at. Or the part, or the chapter, or the division of the Act that you're concerned with. So work out where definitions might occur. never look only at the section you think is the only section that might be relevant. Read around it, look before it to see, are there introductory provisions that modify the meaning of those words? And it's often quite hard to work out whether the words that you're looking at are words that are defined in the Act or in another Act or in the Act's interpretation or another Act, or are they words that are given ordinary English meaning absent any other kind of definition? So they get their meaning solely from the context without the need to take into account a particular definition, or are they defined? And then we know from law school about the use of, in statutory interpretation, about the use of inclusive language or exhaustive definitions. Something means or something includes. They're signals that that you may be bound by, the definition may bind you to not thinking of other possible meanings for that particular phrase, and there's always a challenge. So we won't go through all the cases on statutory interpretation. That's something that hopefully when we do a live cross to Pat Lane, which is with us, we can talk through that. The other thing you should think about doing is, if you're practicing in particular areas, you should keep a collection of statutes. One of the pro tips that people in my chambers do is they keep versions of a statute at a particular point in time. Now, it's a lot easier now with the ability to get this from legislative sites and point in time, but if you have a collection of a particular year, it can be quite handy, because you can say, okay, this is the Australian Consumer Law at a particular point in time, or this is the Competition and Consumer Act at a particular point in time, or these are the rules of court at a particular point in time. And if you've been working with them over a year, then that can be quite handy, because you can make notes on them and the like. But you should keep a collection of statutes, and you can do that electronically as well. You can keep versions electronically. It can be quite handy, because you know you've seen that in earlier legislation, and you get a feel for how things might be changing. The other thing is that within legislative schemes, there are quite different numbering systems. So, for example, in the Tax Assessment Acts, or in the Taxing Acts, or in other acts to do with revenue, there's often a 34-38 or sections that have sections and subsections. Some of the health acts, in some of the other administrative acts, there are different numbering schemes. In, for example, the Copyright Act, there's the use of the famous 135ZZZM, or those sorts of long numbers where if there have been insertions, those insertions have alphabetical addition. So, you know, 13AA, 13AAA becomes before 13AA, and so on and so forth. So as people insert things, they use conventions to insert longer letters. Now, the problem about those kinds of extensions, of course, is that those numbering schemes, you know, if you miss a Z of the ZZZM, you could be in quite a different section. So you need to be careful about properly transposing those section references and making sure that you are careful when you are citing them. But again, numbering systems are different, and that can be quite a challenge, and it has been quite a challenge in Jade to try to deal with it. The other thing is the language, as I mentioned already. The language of statutes is quite a challenge in many cases, and spending time reading statutes and getting a feel for the language can really help you later on in terms of understanding the kind of phrases, the kind of turn of phrase that might be present, that might help you think about other statutes that might be able to help you get a feel for a consideration of the meaning of those kinds of words in that kind of context. And I've said this before about case law, but it's also true of statutes. If you're going to work with a statute, it's a very good idea to print out, at least if it's not too large, the statute or the parts of the statute you want to work with, because printed versions can really improve your understanding, comprehension, and your working with a statute. And for whatever reason, many people say that using a pencil with the printed text of a statute can be a much easier way of getting some inspiration. But again, with tablets, with handhelds, with iPads, with Android tablets, often the paper and online version are just as good. The ability to mark up or line and those sorts of things can be quite handy. All right, so let's move to the next slide, and then we'll go to a demonstration, if we may. So you remember about the geographical and temporal dimension of research. It's of course very true in the case of statutory material as well. The definition of, so knowing what the time, having a chronology to know what is the relevant time, what is the relevant place, which territory, which state, where the events took place, is a very important matter. And you need to understand something about transitional provisions. We're going to talk about that with a live demonstration. So I think what we'll do now, given the time, is we'll take a quick break. The reason we take a break now is so that you can, because these are interactive sessions, if you want to put through some research questions you've got on statutes, we'll endeavour to work through those. Jackie's on the controls and she'll be able to feed those through to us, and we'll work through some research questions. But we'll take a 5-minute break, we'll take a 10-minute break, and we'll resume at 5:30. Thanks very much. Hi, we're just testing the audio at the moment. People have mentioned there were some difficulties with the audio, through Zoom. One of the reasons we've changed this week to using YouTube is the quality of the YouTube sound and the images on YouTube are better. So that's, if you're having the problem where you think I'm standing at the bottom of the well, rest assured I am standing on level 22 chambers. I'm not at the bottom of the well, and if you can't hear me clearly, please switch over to the YouTube page, which is streaming. Jackie is sending the YouTube details inside the Zoom chat, and you'll find it, I hope, better. All right, well, let's get started. So just before we get started, while you're getting settled back into your chairs or standing around jogging while listening to the excitement that only statutory research can provide, people have said that sometimes loading large pieces of legislation can be quite slow. In Jade, that's correct, it has been slow, but we've been doing a lot of work to speed up the loading period, and you should find, if not this week, certainly by next week, if you've thought things were slow, they'll be remarkably faster, and we're doing that using a variety of techniques, but we're making very large changes within Jade to improve load speeds for various kinds, so you'll find that hugely saves time. Now, one of the playful ways, just to show you how we do legal research, if in Jade, imagine I type the word goat into the Omnibox, in the Jade Omnibox. That's the thing at the top, and Nick is going to type in goat and press enter. And you'll see that there are, no, not great, but goat. Goat, yep, enter. Oh, sorry, goat search. We wanted a goat search, please. Now, in goat, when you do a goat search, you'll see that there are, you'll get references to goat in Acts. If we just click out it, so we now see there are 748 results for the word goat, and you'll see that the word goat appears in decisions, and you'll see the Dog and Goat Act of 1866 and 1898. Now let's go to the Dog and Goat Act of 1898, the famous 1898 Dog and Goat Act. Now, what I want to show you there is this act has been repealed, but it's in Jade, and you'll see, remember I said before about how we do OCR, we've done an OCR, but if you scroll down a little bit, you'll see the original text of the Act in its original form in the statute book. So that's what an Act looked like in 1898, how it was written. They're printed, they use big letters at the beginning of the paragraph, so to indicate beginning through a drop cap of the kind of B, being enacted by the Queen's Most Excellent Majesty, and it goes on. So there are sections, there are parts, there's a preliminary description, and there's a material on the right-hand side of the Act, which you'll find in some other states and territories in Australia. So, for example, Victoria still uses this, where there's commentary. So if you look at part 2 of that Act, next to section 2, you'll see that there are the cognate statutes that this section was based upon. And you'll see that if you wanted to look at the original English statutes, you can look at them, and they of course have what are known as regnal, R-E-G-N-A-L years. So the way that statutes used to be referred to before the use of the short name of an act was to refer to the regnal year and the chapter within the Act books. And so you can see 6 William IV, number 4 is the 4th Act of the 6th year of the reign of William IV, and sections 1 and 19 are relevant. And also the 6th Act of the 39th year of the reign of Queen Victoria, section 4. Remember, of course, that you'll then have to go and do your own research in other areas to try to find that, but that's an example of material that's additional to the Act. Now, the Dog and Goat Act of 1898 was repealed by the Dog Act of 1966. And if you're looking for what happened after the Dog Act of 1966, you'd need to look to the Animals Act of 1977 and the Companion Animals Act of 1998 to see how the Dog Act of 1966 was handled. So what's progressively happened is simply searching for goat, you're not necessarily going to find how goats were regulated and what happens with goats. But you probably do need to know about the Dog and Goat Act of 1898, because you'll see that on the right hand side that this act has been cited. Now, it wasn't cited back in 1898, but it was cited as recently as 2013 in a decision of the New South Wales Court of Appeal that is in fact reported in 85 New South Wales Law Reports 768. And we click on that, and you'll see there's a reference to the Dog and Goat Act. And if you go down the decision, you'll see where the Dog and Goat Act is referred to in the body of the text towards the end. So this was an act that this is a decision of a recent Court of Appeal, relatively recent Court of Appeal, considering the Dog and Goat Act and its application, and also, of course, the Companion Animals Act and how that interoperated. You'll see that Section 20, Section 19 of the Dog and Goat Act and Section 20 of the Dog Act of 1966. So even though that material has been repealed, it is an incredibly, you still need to have access to that material in order to undertake proper legal research, properly understand what the case is about, and also to understand something about the way in which different legislation sought to grapple with and differently manage, for example, regulate dogs and goats or dogs, or feral goats. So again, it's not, you can't simply just do a simple full text search. But if we go to the New South Wales legislation site, so legislation on newsouthwales.gov, legislation on newsouthwales.gov.au, you'll see the legislation site for New South Wales. Now, it's a very easy to use site. If we want to do a search, and we want to then look for goat as a standard search, and press search, you'll see the 20, well, there are 26 acts, but you see the first 20 acts, first 20 records referring to goats, so including insurance premiums, the Animals Act, the Biosecurity Act and the like. But they're acts that refer to goats. If, for example, the legislation said any animal, any domestic animal, domesticated animal, does that include feral goat? Well, you don't know, but it may be that a broader term encapsulates a goat, and so it's not always easy to simply use full text searching. You sometimes need to understand the dimension, understand how it might fit together to see if there's an all-encompassing term that may come within which will include the concept of a goat. So a companion animal can, of course, be a goat, because there's an extensive, wide-ranging definition of companion animals. Then there may be other regulations that determine whether a goat is included in a particular act or not. I don't want to go on too long about goats, but I just want to talk about that. But also you need to understand that if you only search in, the repealed legislation as opposed to the enforced legislation, if you go back again, please, Nick, and just run another search. Go back one more level, and you see if we go for repealed and put acts, we check the checkbox at the top. Yep, there we are. And then run goat again. You'll see that the Dogs Act 1966 is there, but but you don't see, if you go further down, you don't see the Dog and Goat Act. So it's quite risky. It's quite risky to use these sites without knowing that there may be other legislation that doesn't come within the material that's included on the site, because it may be not yet digitised or made available. So it's important to take the time to carefully check the material. And so what we do in Jade is we look at all of the material that's been repealed, or as well as still on the statute books, and we try to get all of that material into JADE and indexed and linked. But we're planning to make improvements, and we're always interested to know how we can make things easy to work with. The other aspect of that kind of searching is in New South Wales, when an amending act, because of the Interpretation Act in New South Wales, the effect of the Interpretation Act in New South Wales is that as soon as Parliament has passed an amending act, the amending act itself is repealed, and so it's very hard to find what the amendments were to an act if you use the New South Wales legislation side. It can be quite tricky. Again, it's easy to show in examples, and we're going to do a deep dive into that in a separate session. We won't go into detail today because it takes, to give you an illustration of that, it's easy to show you as a purpose-built video, and we'll do that in forthcoming videos that people can download from the JADE site. But you just need to know that the different states have different methods for repealing legislation as soon as the amendments take effect. So the effect of that is that it can be quite hard to work out how the amendments took place. And what you need to do is in the New South Wales site, you need to look at the repealed legislation that's the amending act, and then you can see immediately what happened. And if there are some amendments that haven't taken effect, they're the only amendments that you'll see in the amending legislation. So it can be quite confusing, and you then need to look at the historical versions as well. All right, let's look at some of the features of the JADE legislation, just some of the other features. If we go back and we look, for example, at the Privacy Act, just to type in the Go box, Privacy Act. 1988 Commonwealth, and press enter. We're just picking this act as an example. The first thing is you'll see that our policy at the moment is to include the entire act, to render the entire act, so you can see all of the parts of the act in a layout, like a table of contents, that can save a lot of time to navigate it. And if you scroll through it, scroll through the table of contents, you'll see that it includes schedules as well. So it's a large act, and one of the most important things in the Privacy Act is the schedule about Australian privacy principles. So you'll need to know that they're there, and they're the principles that, in fact, are the whole reason the Act exists. So you'll remember what I said at the outset, always look at the schedules, always understand what the schedules do. It can be very important if you're trying to deal with privacy regulation. So the Australian privacy principles, which really create the framework under the Act, but what's happened since then, of course, is there are a whole lot of different provisions. So if you go back to Part 8, we scroll up a little bit, and you'll see, public health contact information, Part 8A. Now that whole section was made at the time as a result of COVID and the regulations and privacy protections in relation to COVID. So acts evolve, whether it was in this act or whether it was in the Health Act. It's a difficult question to know which act should these kinds of protections appear. Now that is a choice of the parliamentary draftsperson. It's also a choice of the Parliament as to how to enact particular regulations. So it can be quite tricky finding, where do I find the privacy protections given to me in the COVID period? Well, we found that, but if we didn't know where that was, it could be quite tricky to locate that. And again, it's frequently easier to find that material using secondary sources, but if you look through the material, if you understand something about the practices of legislators, or legislatures, and also parliamentary draftspeople, you can find it more easily. Now let's look at section 94Q. So 94Q. Now, what we've done in JADE, in the legislation, is we've looked through and we've worked out which provisions have a definition, and we've shaded those. So that's a recent innovation, but it means that instead of having to check whether something has been defined or not, we've tried to work out whether there is a definition. The critical part of this sort of legislation, which is complex legislation, is that key phrases like personal information then engage Australian privacy principles. So to understand this Act and its operation and its effect, it takes some reading, it takes some time to ponder it and to understand how the regime works, the complexity of the regime. It's not possible simply to do a search and get an answer about does this Act apply or how it applies. So there are complex questions about how this works. So Division 4 gives you a hint that general privacy measures operate, but you then need to look through to say COVID app data. Well, what is COVID app data? If we click on it, let's have a look. It should pop up. Now, so we then know that we've got to look at 94D5. So we go 94D5. Now, you remember what I said to you before about looking at the whole part of the section you're dealing with. So we click on 94D5, and that will just jump immediately. It should jump in a second once it's loaded. Oh. May just be a delay. If we go to 94D5, I'm sorry about this, but generally it should load, and that's so 94D. 94D. So 94D5, we go down to 94D5, and you'll see there's definition is relating to a person. Again, we've tried to indent, but we don't always get it right, and we're obviously working to ensure that the indents work better. If we wanted to see this whole Act, if you go scroll to the very top of the page, you'll see on the right-hand side there are 2,056 citations to this Act, and these are kept entirely up to date. And most recently, of course, the full court, the Federal Court in 2020 this year has a decision. If we click on that, you'll see which is the most recent citation, where there's a reference to the Privacy Act in the context of industrial law. And you'll see there it is, section 36 is referenced in the legislation, and you'll also be able to find a reference to the section. But if you wanted to see inside an Act, you want to see what is section 36, you can click on it and it pops up just like sections do. So as with parts of, case law, so too with statutes, you can quickly look at that section. If you want to see the history of section 36, when you've got the pop-up window, you'll see there's a view history. So click on history, and you can see immediately we know about two versions, and if you scroll through it, you scroll down the page, you'll see how it's changed, if it's changed at all. If it's changed, it will be shaded, and we'll show you the changes. In this case, there's been no changes. We have two versions, two prints, but if we want to see any changes, they will show up, marked up on the side, so you can quickly see the history of a piece of legislation and how it's changed and what amendments have taken place. All right, and of course, if we go back to the visual history on the top right-hand corner just down and click on there, you can see the visual history of all of the Privacy Act from the first time that we've collected reprints. So if we want to look at when section 94 was inserted, if you scroll down, you'll see the different versions and the changes made. And if you hover over the dots, say you hover over section 89 in the purple, or go into the green. If you go further up in the green, the public service changes, you'll see again changes, what the change was when the change took place, and what the change was. So if we click on Privacy Amendment Enhancing Privacy Protection Act, we click on the green part of that, you'll see that act and how that act has changed. So that's an amending act, and you'll see how the various provisions. So at all times within JADE, you can get back to the instrument that amended the act and to make it easy to work with. All right, so the way in which you can navigate statutes within JADE is, of course, through the Omnibox, the search at the top. You can click references to acts or reprints or sections. You can search for parts of an act. You can use it you can create filters, you can create alerts, you can create saved searches or pinpoint references. Now, one of the areas we're developing, of course, is that when a case cites a statute, it's not always clear which version of the statute it's citing, and we're doing some work to improve that kind of linkage. But again, if you just work on doing regular research and practice, you can get familiar with the use of JADE and the legislation within JADE. What we're showing here, the text that you see on the screen is larger. It's been enlarged to make it easier to read on the video, but when you're at your computer, desktop, the text will be smaller and you'll be able to see more on the page. All right, I'm ready to take any questions now, bearing in mind the time.
I'm just sending through.
Questions? So we have some questions coming in. Good. Some questions? So the I've already answered the questions about large acts. Large acts, we're working on improving the load speed of large acts, so we're doing some work to improve that. So that's going to be particularly with rules, with sections. If you're doing shorthand searches, for example, if you want to search the ACL section 18, you can type ACL space S18 or section 18 of the ACL or section 18 ACL. So you can actually, in the Omnibox, find sections really quickly and load those. A great feature that we've got is in the Evidence Act, because the Evidence Act, so the Evidence Act is a good example where there are six Evidence Acts that are all cognate. They all have the same sections and pretty much have the same parts. The Evidence Act, so there's the Evidence Act Commonwealth 1995, there's the Evidence Act New South Wales 1995, there's the Evidence Act 2001 Tasmania, there's the Evidence Act 2008 Victoria, there's the Evidence Act 2011 ACT, there's the Evidence National Uniform Legislation Act 2011 Northern Territory. Now, say you wanted to look at the business records part of any of those acts. If you were doing it in the old way of searching using full text searching, you would find the Evidence Act 1995 Commonwealth, section 69. But what you really want to know is, given that they're the same provisions, identical provisions, you want to know what is the most recent consideration of section 69 of the Evidence Act, regardless of which particular enactment it's in. And so there's an opportunity to do that in JADE using cognate sections. And we'll just do that now as a demonstration. Nick's going to pull up section 69 of the Evidence Act in our demonstration in JADE, and then we're going to look at that. All right, so we're waiting for it to load. Of course, Murphy's Law.
This is the Commonwealth Act. Do you want New South Wales?
No, oh, it's good. Let's say New South Wales. We've got to load. Do we have the sidebar? Is it loaded or is it Too many items. If we go to the very top.
Go to the top.
Yep. Huh. So there's only 3 citations. Try New South Wales. Something wrong with that. Right, so the Evidence Act, let's go to section 69 of the Evidence Act New South Wales. We've just made some changes, which is an example of, so section 69. Now, so it's an exception for business records. We all know that exception well. What we now do is we have cognate provisions of the Evidence Act. So you don't need to, well, you won't see this here, but I'll show it. We'll show it in the coming few days. The Evidence Act, you can simply look at the Evidence Act regardless of which jurisdiction you're in, and you'll find all those references to section 69. It's not showing at the moment because we're doing a massive reparse, but it will show in the next period. The other thing you can see is we understand the structure of an act. So if you're looking for cases about section 69(1)(a) Roman 1, you can search for those in greater detail. And so you can find the cases that just refer to that particular provision, rather than only look at section 69, and you can zoom in or zoom out from the particular provision. So we know about the context of an act, we know how the sections work, and as with case citations, with legislation citations, we always show the basis upon which we think that there's a match. So you can quickly find why we think that we've matched the particular section. If you wanted to have a look at Anton and Bocan, which is the 3rd of October 2018, and clicked on that, it will take you straight into that section. Again, remember from the last time you'll see this has been appealed. So if you wanted to look at the appeal, you can go straight into the appeal, or the first of the appeals. So that's the third of the appeals, but you look at the prior decisions in the Court of Appeal. So NSWCA 40 would be your best bet. And possibly 250. NSWCA 250. 250, no, go up to them.
Oh, sorry.
New South Wales CA 250. Yep.
Sorry.
You'll see there's the decision, appeal dismissed with costs, but you can quickly see references to the various other provisions. But again, you can go through and quickly jump between case law and the statutory material in its various forms, and you can do so with cognate provisions around Australia. All right, are there other questions we've got? So the question was, is the amendment visual history comparison available in all jurisdictions or just Commonwealth? The answer is it's progressively available in all jurisdictions. You may find, because of the change we're making currently to legislation, that there'll be a small delay for acts that are heavily cited, but they'll be cached, and we're fixing that up. So the answer to that is, as we progressively add historical versions in, that material is available in that kind of visual history, which can be very helpful. Is there an ability? Another question is there an ability to see all subordinate instruments for any given act, similar to the cases cited to when looking at case law? The answer to that is that's our plan, to look at subordinate instruments. One area of complexity, of course, in the case of planning instruments that are made arguably under planning power given in quite complex areas. But yes, we'll be doing that. And we're going to rethink the interface for statutory material. So the right-hand box for case law, and we're improving that to make it easy to work with for legislation. What else is there? Any other questions, or does anyone have any commentary? All right, well, so the first point is always check that the legislation you're working with is the legislation you need. That may sometimes mean that you need to look at repealed legislation because you may be considering something in the past. So bear that in mind. It's not a bad thing that something's been repealed, you just need to know that you've got the right instrument you're considering. It can be quite a challenge to work out what is the particular statutory instrument that is being considered by a court if you're trying to work out what was really considered, what principles were considered, whether they have a binding force, and that can be quite a challenge. For example, in intellectual property cases, it can be quite a challenge to work out the earlier acts, the 1955 Trademarks Act, for example, rather than the 1995 Trademarks Act, to work out how those acts interact, and we're working on improving that kind of linkage through cognate provisions as well. But as with everything that we've done with Jade, if there are things that you think can be improved, or you have ideas or things you'd like to see happen with it, please let us know. We're looking at statute collections for particular practice areas, or particular areas of practice, I should say, and that's an area where then you can get a compilation of materials that you can find easier to get your bearings if you're looking, for example, about goats and you wanted to know about all goat law. But more simply, for example, if you were looking in areas to do with, say, energy regulation or like, you'd be able to find that material collated into one spot. We're starting with court materials of court, materials for rules of court and the like, but we're working with in relation to other areas. So if you have particular practice areas you're very interested in seeing us provide collations of statutory other material in relation to it, please let us know, and we will perhaps enlist your assistance in giving us some advice about what should be in that grouping. Well, on behalf of Level 22 Chambers and the team at Barnett Jade, I'd like to thank you for joining us, and thank you again for all to Nick Clark and to Jackie Charles for their hard work in making this event possible, and to the team at Barnett Jade who have obviously made all sorts of behind the scenes improvements to Jade, not just in the last 3 weeks, but over the last many years. We're driven by your support and by the assistance we get from the wider legal community, and so feel free to always make those suggestions. That's how we make Jade the legal research tool that we all wish to use. Thanks very much and good evening.